Be ready for the dictation. Start. Leave granted feeling aggrieved and dissatisfied with the impugned judgment and order dated 6th May 2015 passed by the High Court of Judicature for Rajasthan at Jaipur in SB Criminal Appeal number 36/1993, by which the High Court has partly allowed the said appeal, and while maintaining the conviction of respondent number 1 herein for the offence under section 307 IPC, has reduced the sentence from 3 years rigorous imprisonment to the period already undergone by him in confinement, 44 days, and so far as the accused, Mohan Lal, is concerned, the High Court has not interfered with the order of the trial court convicting him under Section 324 IPC and releasing him on probation under Section 360 CR.P.C. The state has preferred the present appeal. That the respondents herein and others were tried by the learned trial court for the offences under sections 147, 148, 149, 447 and 323 IPC, and also under section 307 IPC, so far as accused Banwari Lal, respondent number 1 herein, is concerned. Respondent number 1 herein, Banwari Lal, was tried for the offence under section 307 IPC for having caused grievous injuries on the skull middle of the head of the injured person, Phul Chand. That the injured Phul Chand sustained one lacerated wound of size 10 times 1 cm's bone deep extending up to brain membrane in the center of the skull, and the bone was emerging out. He also sustained other injuries. On appreciation of evidence, the learned trial court held that the prosecution has proved beyond reasonable doubt that the injuries suffered by the injured Phul Chand, which were caused by the accused, Banwari Lal, were sufficient for causing death in the ordinary course of nature. By observing so, the learned trial court convicted the respondent Banwari Lal for the offence under section 307 IPC and sentenced him to undergo 3 years rigorous imprisonment. However, so far as the accused Mohan Lal is concerned, the learned trial court, though convicted him, but granted the benefit of probation. Feeling aggrieved and dissatisfied with the judgment and order of conviction and sentence passed by the learned trial court, the respondents, accused Banwari Lal and Mohan Lal, both preferred an appeal before the High Court. Before the High Court, the main submissions were made on behalf of the accused Banwari Lal, in which the respondents did not challenge their conviction but prayed to reduce the sentence so far as the accused Banwari Lal is concerned, on the grounds that occurrence took place on 31st March 1989, i.e., about 26 years ago, that they were facing trial since last 26 years, and when the occurrence took place, they were young and now they are old-aged persons. It was also submitted on behalf of the accused Banwari Lal that as the benefit of probation has been given to the accused Mohan Lal, he may also be given the benefit of probation. Thereafter, without assigning any further reasons whatsoever and without considering the nature or gravity of offence and the serious injuries caused by the accused Banwari Lal on the injured Phul Chand, The High Court has partly allowed the said appeal and while maintaining the conviction, has reduced the sentence to the period already undergone by him, 44 days. The High Court has dismissed the appeal in respect of the accused Mohanlal. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court, interfering with the sentence imposed by the learned trial court and reducing it to the period already undergone, 44 days, from 3 years rigorous imprisonment imposed by the learned trial court insofar as accused Banwari Lal is concerned, as also confirming the order of probation insofar as accused Mohan Lal is concerned, the state has preferred the present appeal. There is a huge delay of 1880 days in preferring the appeal, and therefore a separate criminal miscellaneous application is filed by the state, praying to condone the delay.